ladies sing this song. Do-da, do-da, the camp town race back 5 miles long. Oh, do-da day, I come down with my hat gaping. Do-da, do-da, I go back home with a pocket full of steam. Oh, do-da day, why to run all night? Why to run all day? I'll bet my money on the bobtail leg. Somebody bet on the bay. Why to run all night? Why to run all day?
Well, that rendition of Camptown Races will let you know that today we're talking about horses. It is a day at the races today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, March 12th, 2024. And yes, we are going to be talking about a case today about whether you have a constitutional right to name a horse that makes fun of someone. That is, the name makes fun of someone. It's also got some administrative, procedural roadblocks and all that kind of stuff that we often talk about Short Circuit as well. So we'll get to that a little later in the show. And at that time, we will be hearing from IJ's Christian Lansinger. So Christian, I think it is your second time on the show. So welcome back to Short Circuit.
Thanks, Anthony. Good to be back.
But first, before all that, we are going to be discussing a case that does not involve a horse, but it does involve Florida's Governor Ron DeSantis. Now, we talked about a case a few weeks ago where Governor DeSantis and the legislature had some work that the 11th Circuit was not very impressed by and sent it back down. That was a First Amendment case. That was the Disney case. Well, now we have another First Amendment roadblock that the Florida legislature has apparently run into involving the 11th Circuit. And this time it is about the Stop Woke Act. I mean, who doesn't like the sound of the Stop Woke Act? Well, we'll hear why there were some problems with this law. And to bring us that news is one of IJ's First Amendment experts. He is also the managing attorney of our office way out in Arizona. We brought him all the way from Arizona to Florida for this, and that is Paul Avelar. Paul, welcome back to the show. And I'm guessing you yourself also is not, you wouldn't describe yourself as exactly woke.
Anthony, always good to be back. No, probably not. I think more importantly, most people wouldn't describe me as woke.
But yet, you might have some sympathy for how the good conservative judges on the 11th Circuit said that there was this law itself maybe had some problems, and those have to do with the First Amendment.
Not maybe. It definitely has some problems. So as you said, this is all about Florida's Stop Woke Act. Woke is actually an acronym here. It stands for Stop the Wrongs to Our Kids and Employees. And that's strike one, because any bill, any law with a cute acronym usually is highly questionable, and frankly, all of them should be declared unconstitutional as just misleading people as about, what they're actually about. But setting that little issue aside, what the Stop Woke Act does is it said that, in relevant part, employers cannot subject, quote, any individual as a condition of employment to training, instruction, or other required activity that espouses, promotes, advances, inculcates, or compels, unquote, a certain set of beliefs, and then it has a list of 8 sorts of topics, beliefs, subjects that were prohibited from being trained, instructed, promoted, advanced, inculcates, or compels. And you'll notice that all of those action verbs right there are really just stand-ins for speech, specifically the idea or sharing ideas. Now, whether you agree with these ideas or not, and I think the panel sort of went out of its way to express some sympathy with the idea behind the bill. Ultimately, what the panel says is, look, this is a restriction on speech. After all, and not only a restriction on speech, a viewpoint, content and viewpoint-based restriction on speech. because the law prohibits requiring attendance at these trainings only for trainings that endorse those sets of ideas. Employers could still require employees to attend sessions that rejected those ideas or presented them in an objective manner without endorsement of the concepts. And so, that looks like a pretty straightforward classic First Amendment type problem. The government is regulating speech based on not just content, but also viewpoint. And there's just a whole host of cases that say you can't do that. But, aha, says Florida in a now very familiar move that lots of governments all across the country try every day. We're not restricting speech, they say. We're not regulating speech. We're regulating conduct. We're not stopping anyone from saying what they want. We're simply prohibiting mandatory meetings. And meetings are conduct. They're not speech. And so this isn't even a restriction on, although it's content and viewpoint based, it's not a restriction on speech at all. This is just conduct. And as listeners here know, that's an important distinction because speech receives actual judicial review in our system where the government has to justify its reasons for having these things, has to show some sort of tailoring, et cetera. And restrictions on conduct, however, receive rational basis review, which, again, everyone knows requires neither a rationale nor a basis to be upheld. And so the court is very familiar with this move, as they say the characterization reflects a clever framing rather than a lawful restriction. And so recognizing, of course, that there is huge reason for or encouragement for government to call things a restriction on conduct when they're really restricting speech because they're hoping that'll get the courts out of the way of actually analyzing these things. The court makes short work of all of this. It goes through its usual analysis and says, no, look, the restriction here it turns entirely on the content of what is presented at one of these meetings. And where a regulation turns on the content of the speech that's involved, that's not a regulation of conduct. That is a regulation of speech, and that's part of a long line going back to at least Holder v. Humanitarian Law from the U.S. Supreme Court that recognizes that's the way you do this sort of analysis. And so having very easily decided that this is a restriction on speech and not of conduct, the court then applies the usual rules when it comes to strict scrutiny and regulation of content of speech, and says, no, this bill does not meet those high standards. And at that point, it's a very straightforward First Amendment case. But I think the real move here, of course, is to recognize this speech conduct distinction and to really meaningfully engage with that analysis. As all of us here at IJ know, courts are not always great at doing that, at making this speech conduct analysis and really drawing those lines. It's nice to see the 11th Circuit do that, although I should note that the 11th Circuit itself does not always do that. There are other cases in the 11th Circuit which say, this kind of looks like a restriction on speech because it's stopping you from speaking, but really we're going to call it a regulation of conduct, and that conduct is the practice of an occupation. One would have thought that the U.S. Supreme Court had sort of nipped that in the bud. In the NIFLA case several years ago, the 11th Circuit continues to struggle with it. Lots of circuits continue to struggle with it. The Ninth Circuit is clearly struggling with it right now in a case that I'm litigating. So this is mark this one as another win for speech because the court does this hard, in this case, easy conduct speech analysis, comes down on the right side, and after that, First Amendment applies, and we all know how that's going to go.
It really is interesting when you hear it says Stop Woke Act. They're not really hiding the ball there. Stop insert ideas. And then they go even further to list out the ideas 1 through 8 on which ideas they think are not okay. It's definitely a different case from what we're used to when we're dealing with the practice of an occupation where they're just saying we are stopping this speech in the actual name of the bill itself.
Paul, I think you made a really good point about how this is pretty straightforward. A lot of people who really no classic First Amendment law would read this and kind of go, duh, like, obviously it's going to go that way. But the 11th bunch of circuits, including, as he said, the Ninth Circuit very recently in an IJ case, the 11th Circuit has gone both ways on the question of conduct and speech. And it's done it a couple times, or more than a couple times, when it comes to occupational speech. And I was just reminded this morning, a case that our old friend Clark Neely litigated a few years ago about interior design licensing in Florida. And basically what was being licensed was someone stating to someone else about how they should design their office or their house or whatever. And so if you were to just draw a picture of how the office should look, that was considered regulated speech. And if you didn't have a license, that could actually violate the law. And so in light of that case and the follow-on cases that have come from that, at least on one side of, these lines of cases, the 11th Circuit, you can't think that the legislature and Florida's council were all that crazy for thinking maybe they get away with this case. I mean, this is obviously kind of more core ideological speech, but those are cases about speech. And so, why not give it a shot? So although the panel, you read this opinion and the panel's like, WTF, get out of my courtroom. We'll go through the ringer here. But of course, this violates the First Amendment. It wasn't crazy for them to try.
Yeah, the 11th Circuit points out that and this is a quote from them, the comparative freedom to regulate conduct sometimes tempts political bodies to try and recharacterize speech as conduct. And that's really what they're going for here. Because if it's conduct, then they have free reign to do what they want, almost free reign to do what they want. Speech still gets real judging. And so that distinction, speech versus conduct, is critical for courts to really engage in.
There's one great, there's a few great lines in this paragraph, Judge Branch as the author, but when Florida keeps coming up with like nuances on how to say that this is actually conduct and not speech. One remarkable paragraph says, Florida proposes an alternative approach. It says that even if speech defines the contours of the prohibition, so long as the resulting burden is on the conduct, that conduct is all the state is regulating. That in turn means the law does not regulate speech. Remarkable. Under Florida's proposed standard, a government could ban riding in a parade float if it did not agree with the message on the banner. So I love that one word sentence there. Remarkable. You can always tell if that's in the opinion, you're probably not doing very well.
In Florida's defense, and I don't really mean this as a defense, it's not the first government to come up with this sort of argument. There have been arguments before, like there's an Eighth Circuit case involving a video production company where the state tried to regulate the content of what the video production company could do. And they said, oh, we're not regulating the content of the speech. We're regulating things like where you can place the microphone and how you turn the camera on. At some level, all speech involves conduct, right? Me typing on my computer results in speech, but typing is literally conduct. Only a fool would say that, oh, I can regulate what you're typing, and that's a regulation of conduct, not of speech. But, the government's full of fools sometimes.
We've seen in some IJ litigation, too, out of North Carolina, where drafting a report, the government was trying to distinguish drafting a report from the opinions that are actually contained in the report. And it gets to the point where you start narrowing this down. It's that you use your vocal cords to speak. And you can really recharacterize or reframe as the court language the court was using to change speech into any action, because speech is an action after all. But just making the verb weaker doesn't actually change the fact that what's going on here is somebody trying to communicate a message to somebody else, whether it's in a workplace mandatory training, whether it's in a report, whatever it is. If somebody's trying to communicate a message from person A to person B, that's speech.
And Judge Branch points out that the classic example of that, at least in modern times, is the burning of a flag. That is conduct. I mean, that's fire, but it is about the speech because it's what you are burning that is regulated.
And that's really an important, and that goes to conduct versus speech, right? If you prohibit someone from setting fires, and that then limits them from setting a flag on fire, then that's one thing. But if you are limiting them from setting flags on fire, to ban protest, that's clearly a regulation of speech. The United States Supreme Court figured that out a long time ago, and it's just a question of how are these the lower federal courts really sort of dealing with those sorts of distinctions and, quite frankly, messing them up in a lot of cases. There is, I think, a number of conflicts and splits amongst the circuits right now, and even within circuits, on exactly how they're dealing with this. A lot of this has come post-NIFLA, where the U.S. Supreme Court said, look, just because speech is uttered by a professional doesn't mean, and part of a licensing scheme, doesn't mean that the speech isn't protected, even if the licensing scheme is generally one of conduct. That there are these things called as-applied regulation out there. Stop woke is a different sort of case because that one's just pretty obvious. But there are a number of these other cases out there where the restriction on speech, the courts maybe think is a little more subtle, but a subtle restriction on speech is still a restriction on speech.
And finally, an amendment to what I said earlier. I said recently we covered a different Governor DeSantis involved First Amendment case that had to do with the Disney kerfuffle. That's not the case that we covered. We covered the one about the prosecutor Andrew Warren, who was fired, and then his that was reversed by the 11th Circuit because there was impermissible First Amendment protected motivation. Hard to keep our Florida and 11th Circuit First Amendment cases straight these days, so my apologies for that. Now, another case that eventually is going to be about the First Amendment, but isn't quite yet, but you get a little preview what it's going to be about, is out in the Ninth Circuit, and this is where we're going to get a little horsey and go to the races. So, Christian, I guess take it away, and they're off.
And we've actually, in short circuits, done horse racing before. I think it was in late 2022. You had another horse racing case, I think it was out of the Fifth Circuit, dealing with the non-delegation doctrine.
Yeah, and I think we may have used up all our horse puns that time. But if you can think of any more,
I don't think the guest on that show, I think he's got a few more puns up his sleeve than I do. But that being said,
that was our punter in chief, I believe, Trace, who is no longer working currently at IJ, but he's a master of the pun. Yes.
But that case dealt with the Horse Integrity and Safety Act, which is a federal legislation. I think there was a debate as to the pronunciation of that statute in that short circuit podcast. But here we're dealing with state regulation, specifically out of California. And the issue we're dealing with is what's called administrative claim preclusion. And in layman's terms, all that really means is when you bring a case before a state agency, in this case, it was the California Horse Racing Board, and you get a decision from that state agency, can you then after that file a federal lawsuit, specifically a Section 1983 lawsuit, which is the federal statute that allows you to file a claim for civil rights? Can you file that claim, or is the state agency decision, does it bar your subsequent federal claim? But before getting into that mess, it's important to really see the players that are involved here, because it's really quite interesting. We start with Bob Baffert, who is a Hall of Fame horse trainer. I think he has tied for the most wins at the Kentucky Derby with 6 horses winning the Kentucky Derby. But he has a bit of a problem with his horses testing positive for drugs. He's had over 30 horses in his career test positive for drugs. And
that sounds like a lot.
You'd think so, which is maybe what's the motivation behind some of these regulations. But clearly they're not working that well. Even in 2021, one of his horses that won the Kentucky Derby, I believe it was the Medina Spirit, won, but then was subsequently disqualified due to a positive drug test. So in comes our plaintiff here, Jerry Jim Gotchian, which I'm likely butchering that last name. But he's another horse owner who isn't fond of Bob, nor is he fond of the California Horse Racing Board. He's a very litigious individual. He's filed a number of lawsuits over the past decade, and he's named horses as well. And that's something that he does is he goes after the board, he goes after the other horse owners because he thinks that a lot of this isn't done the ethical way or the right way. And so him and the California Horse Racing Board don't get along too well. One of the former chairs of the California Horse Racing Board described him as a, quote, self-destructive person with a mean-spirited persona. Another former chair of the California Horse Racing Board pled no contest to keying Jerry's car. So it's short to say they don't get along too well. And so he has kind of a new strategy maybe that you would think is a little bit less harsh. He names his horses to make fun of people he doesn't like. So in regards to Bob, he named one horse Bad Test Bob. And then the horse that's relevant here was Malpractice Meuser. Again, I might be butchering the pronunciation there. But that's named after one of Bob's attorneys, Michael D. Meuser, a Kentucky-based lawyer. And although at the same time, Jerry doesn't seem to want to say in his briefings that that's actually why these horses are named this, he seems to say it might be named after somebody. But at the same time, it seems pretty clear from his over 10 years, in his 10-year relationship, if you will, with the California Horse Racing Board, that they're not too fond of each other, nor is he seem to be fond of some of the people who allegedly dope their horses. So anyways, what happened here was he tried to race Malpractice Meuser in California, and he was unable to because there's a regulation where if the horse has a disparaging name, that horse will be denied registration in California. And it's not actually California that it's not the California rule, but rather they make you get a registration from a private group called the Jockey Club of New York, and it's their rule.
And that itself sounds like some kind of non-delegation problem.
And they raised delegation arguments here, but they raised it only under the California Constitution. So it got dismissed on sovereign immunity grounds.
Okay.
But that being said, there was some at least discussions on whether that was improper delegation. But either way, he goes to the board in California and says, I should be able to race my horse. This is ridiculous. I should be able to race Malpractice Meuser. This is a First Amendment issue. They say, no, you're not registered. So he appeals to his good friend, the California Horse Racing Board, and alleges First Amendment violations, among other claims. And shockingly, the California Horse Racing Board does not decide for him and says, no, you do not have a right to race your horse in California. And not only that, though we don't have the right to actually rule on your First Amendment claim under the California Constitution, because we're a state agency, and under the California Constitution, California agencies aren't allowed to declare statutes or regulations unconstitutional. Nevertheless, they went out of their way to describe in detail why they think his First Amendment claim should fail at the state court, should it get there. So what happens there is Jerry, instead of going to state court and pursuing his claim through the California courts, which probably wouldn't be too fond of his claim, he goes to federal court, which is a normal thing you do in Section 1983 cases, because Section 1983 is meant to provide a federal forum to vindicate your constitutional rights. While he's doing that, the federal district court jumps in, and despite it not being briefed, the federal district court on its own accord asks, isn't there something wrong with this, and don't we call that claim preclusion? What they wanted to know is if you bring a case to the California Horse Racing Board, they issue a decision discussing the First Amendment issue, combined with the fact that you could have raised that issue later on in state court, does that somehow bar your federal claim? And shouldn't you really be in state court, not here? The district court ultimately said, yes, that is true, and dismissed his case. And he appealed up to the Ninth Circuit, where the Ninth Circuit reversed and said, no, there's a long-standing principle of Section 1983 law, which is that you don't have to exhaust your administrative remedies just to get your day in federal court. What they said was, there's a federal statute which says, it's called Section 1738, which is federal courts give the same preclusive effect to state court judgments. Note that state court judgments, not state agency decisions. When it comes to state agency decisions, the Ninth Circuit ruled that federal common law applies. And the way they interpret federal common law is that you have to consider whether the agency decision was fair. And one of those key fairness factors was, did the person have the opportunity to actually litigate their claim in front of the agency? And here, that wasn't the case. The California Constitution bars his First Amendment claim. He's not allowed to bring it before the agency, so how could it have even been decided in the first place? So it makes no sense to actually preclude the claim in the agency, but when, in that case, the agency could never have ruled on the issue in the first instance. The court went further, and it tied in this cardinal rule about exhaustion into its reasoning to say administrative exhaustion isn't required. And so if we were to rule for the government here and say this claim is precluded, we'd create what the Supreme Court warned about, which is they call it a preclusion trap, which is the fact that if he actually went to state court to actually get his claim litigated, like they say he has to before he has a right to then seek federal review, his claim would then be precluded. So it creates this no-win situation where he's not allowed to go straight to federal court without exhausting his state remedies and his right to judicial review in the California courts. But then if he goes to the California courts, he's then precluded. It's a no-win situation, or as the Ninth Circuit called it, a heads I win, tails you lose. So overall, the Ninth Circuit reaffirmed the longstanding principle that you can go to state court or federal court. It's your choice when you have a Section 1983 claim. And ultimately, this reaffirmed that principle, and it allows someone to have a federal forum for their Section 1983 claim.
Now, Paul, you have done this preclusion trap dance a few times. Am I correct?
I have, yeah. It's pretty common for anyone who is litigating when state administrative agencies overstep their bounds, where they do something to your client, and at that point you're left in this conundrum, which is, do I take this up through the state system, through an administrative appeals process, and thoughts on that later, or do I just sort of cut bait and run to the federal courts, which are supposed to give you a forum for protecting your federal rights against abridgment under color of state law. That's 1983. Where we used to see this all the time was in takings law. There was a case called Williamson County that actually required exhaustion of state remedies before you could go to court. And then a couple of years later, in a case called San Remo Hotel, the Supreme Court said, oh, wait, but once you do that, then you're stuck with all of these claim and issue preclusion problems, so you can't really litigate this in federal court either, effectively cutting you off from the federal remedy that 1983 was meant to give you in the first place. A couple years ago in Nick, the Supreme Court revisited that and said, no, that's all wrong. In order to protect federal rights, you have to have a federal, at least you have to have a federal forum for these things. And so the Ninth Circuit's decision here is understandable. It's correct under governing law, and it's for anyone who faces adjudication by a state agency. This is the sort of thing that they face in all of these sorts of things. And if I can just rant for 1 second about separation of powers and this notion of administrative adjudication.
Do please. It's
gotten out of control, what these state agencies think that they can do. There's this, line in here about state agencies, judicial acts, and no agency should be able to engage in judicial acts. Separation of power says only the judiciary can engage in judicial acts. And one of those is declaring a law unconstitutional. Strictly speaking, no state. California is simple. There's an express provision in California's constitution that says state agencies have no power to declare acts of the state unconstitutional. Only a court can do that. You don't even need that expressly. That's just inherent in what the judicial power is. And so is or ought to be the law in all 50 states and the federal government. The U.S. Supreme Court oftentimes says that sort of thing. Last term, you saw that in two cases called Cochran and Axon, which talked about your need to go through an agency adjudication in order to challenge some structural problem with that agency adjudication. This term, there's a case pending called Jarkissi versus SEC, which really talks about what is an agency's ability to impose fines on you for having, violated the law in some way, in a civil capacity, and is that allowable under Article 3? Each of the states has their own separation of powers provision, and so I think this is an issue that's going to begin to get more and more traction, which is actually what are these agencies doing in the first place? Because if they can't adjudicate, then how can you claim to be giving their decisions preclusive effect as judicial judgments? That makes absolutely no sense whatsoever from a sort of question of first principles.
And it's interesting here. I mean, you have a hearing officer that ultimately is the one that proposed a decision, but it is ratified by the board. And the board isn't composed of 7 lawyers. It's composed of 7 people appointed by the governor. And you have this with these administrative agencies. They're not necessarily a bunch of constitutional litigators or judges with a bunch of experience in dealing with constitutional issues. And a lot of times they're intentionally designed to include people that are actually in the industry itself. So to trust those people to actually litigate the First Amendment claim fully, and then to say, okay, now we're done here, the federal courts don't have a right to actually hear a Section 1983 claim, it creates a lot of concerns for constitutional litigators.
And it shouldn't matter for the choice of federal or state court, but I would also be curious as to how this actual appeal would work to state court. So say they had rolled the dice and said, we're just going to stay in the state system, and then gone to state court. I mean, often with those procedures, it's just kind of an old-fashioned writ, how you go to the state court, and there's no, discovery. You can't add to the record. You have the record below, which was built in not in any way like a normal adjudicative forum where you have, you can do depositions and let alone a trial or something like that. So often my experience is that the little I've been involved in this in some states is you go to state court. So you have this, if people do go to state court, they have this not very good opportunity to build a record. And so they add on a Section 1983 claim. And a lot of states will say, okay, you can do that. So now we'll do this in state court. And so really it's just a Section 1983 claim, which, then raises the question, okay, well, how about you just do it to federal court in the first place? And then you can get your federal forum, which really it looks like is what, happened here. I mean, I don't know the California procedural law here, but and if you can do one, you should be able to do the other. And the whole point of having Section 1983 in the first place is to have that federal forum. And so that's what's going to end up happening.
Right. And I know it's a writ of mandamus. I'm not sure if you compare a Section 1983 claim or and sometimes you might be required to for concerns of waiver when it comes to the state level. But regardless, it's still important that we have that federal forum for the fact that a lot of times you still have to go through the agency first for standing reasons. You need the government to show affirmatively that if you go to the federal court, try to go to federal court first preemptively without actually having the agency establish that what's going on, for them to actually position themselves to say, no, you can't name your horse Malpractice Meuser. But if they don't actually establish that, they can then go in court and say, oh, we never actually ruled. Maybe we think that name's okay, and we don't know until you actually come see us at the agency court, where maybe we'll rule for you, even though in practice they almost never do.
Well, and as we discussed just on last week's show, when we had Justin Pearson on in a property rights case, that part of Williamson County is still good law, that you need to show that this case is ripe. So usually that means asking for a variance. And then when that's denied, then you can go to federal court. And kind of what they did here was ask for a variance in some way on their on the Malpractice Meuser.
Right.
Yeah, we've talked about this a number of times on Short Circuit, is that really all constitutional law comes down to weird procedural issues. And so anyone who is really interested in substantive constitutional law had better be an expert on procedural stuff, because you will end up, as here, litigating all of this stuff for years before you ever get to, hey, does the First Amendment actually protect my ability to name a horse whatever I want to name it?
And I will remind listeners that we are, as always, hiring at the Institute for Justice. And so come and do all the headbanging that you want that Paul was just talking about against a wall on procedural stuff. And eventually you can get the merits. And I think we should close by looking in the crystal ball here a little bit on the merits. So Malpractice Meuser finally gets its day in court. The owner does. And really, this rule is a private club that has been given state power. It can veto names. And so it's not that the horse can't be named that, it's that it can't be raced professionally in California with that name. I can't see any way that this, under a real First Amendment application, like we had, say, at the 11th Circuit this week, survives. I mean, I guess they want sportsmanship in the sport is really is that going to meet strict scrutiny? Or would it be commercial speech because it's the name of a racehorse?
There's a 2017 case, Matal v. Tam. I think I'm digging back from my business torts class in law school, but it dealt with a trademark where an Asian American band, I think, was trying to recapture their band name. They wanted to call themselves the Slants. To kind of recapture the name and to own it. And they actually, for a very similar reason, got denied that trademark because it was disparaging towards themselves. And so they went up to the Supreme Court, and the Supreme Court struck down that restriction as a viewpoint-based restriction. So yeah, I don't think if the First Amendment issue is actually heard in this case, I think it's pretty clear cut. It's just with all of the different issues dealing with delegation, as we discussed, among other problems, I don't know if the merits will ever be reached.
Well, we'll see if one day perhaps we can place a bet on Malpractice Meuser. Maybe we'll follow up with that one day. But for now, I'd like to thank Christian and Paul for a little bit of First Amendment and procedural talk. And everyone, next week is going to be a special about a new report we have at the Institute for Justice. So I want everyone to stay tuned for that. But in the meantime, I hope that everyone gets engaged.